Approximately 2 years ago, I defended myself after being assaulted by my stepdad. My actions fell completely under the Kentucky Revised Statute 503, which legally protects self-defense when a person reasonably believes they are in imminent danger, as you see here. The use of physical force by a defendant upon another person is justified when the defendant believes that such force is necessary to protect himself against the use or imminent use of unlawful physical force by the other person. Yet, when officers arrived, they ignored the full context. They arrested me without taking my statement. They had a conversation with me, but never formally took down my version of events. Instead, they rely on a partial remark manipulated into a fabricated statement and used it against me in court, which is also called admission. But an admission is not a statement. Here's where it gets worse. In trial, Deputy Perkins, which was the lead officer and the arresting officer, admitted on record that he took my statement from other officers' body cam footage. But the footage does not contain an actual statement because I never gave one. So how did law enforcement justify my arrest? Sorry, I'm going to have to turn this away. Okay, let's just make sure I got it all because it was showing down there. It says footage does not contain actual statement. So I don't know why it's screwing up. But anyways, let's continue to the next one. Now let's look at the differences between a comment, a statement, and an admission. A comment is a casual remark or informal observation, not officially recorded or intended as evidence. A statement. A structured, intentional account given for legal purposes. Statements are recorded, signed, or formally documented. Admission. A voluntary acknowledgement of a fact, but not necessarily a structured statement. Admissions may be used as evidence, but they are not the same as full statements. Why this matters? Law enforcement cannot legally treat a comment as a formal statement without informing the individual, which they never did. If they fail to notify someone that what they say is being used as evidence, then it does not qualify as a proper statement under evidentiary standards. Sorry, I had a problem with that word. It's like Miranda versus Arizona. This is where they've come up with the Miranda rights. Because same situation as what we're going through right here. So they created the Miranda rights. You have a right to remain silent. Anything that you say can and will be used against you in a court of law. Now that's telling you, if you make an admission, it can be used against you. Then you got the Kentucky criminal procedures. Evidentiary standards. A statement must be properly documented to be legally valid in court. Misrepresentation of evidence, which is KRS 522, and I'll show you that here in a minute. If officers falsely claim a comment is a statement, it could be considered official misconduct or evidence tampering. Sorry, I was going to put this on my YouTube and have a robot say it for me, but I'm just going to do it myself. How my words were fabricated and why it violates due process. During the incident, I said, when my stepdad hit me, I hit him back. That was a casual remark, a comment, not a structured statement, yet officers twisted this into a formal statement and used it against me. Without informing me, law enforcement misrepresented my words and treated a fragmented comment as a statement and violated the evidentiary evidentiary, standards. Sorry about that, guys. I really have a problem with that word. Legal violations that impacted my case. Due process violations, 5th and 14th Amendment. My right to present exculpatory, I have a problem with that word too. Evidence with structure, I'm not even sure if I said that right. Okay, forgery, which is KRS 516. Law enforcement falsified or altered a statement. Official misconduct, KRS 522. Deputy Perkins knowingly misrepresented evidence in legal proceedings. Discovery violation. Here's the thing, because I filed a motion of discovery to get all the police body cams, right? It was introduced to the case, but it was never presented in the trial. Body cam footage that could have exposed this misconduct was suppressed in trial. They never presented it. The missing body cam footage, which I don't think it was missing, it wasn't suppressed either. They just never put it in the trial. Before trial, my public defender filed a motion of discovery requesting body cam footage from all officers presented at the scene. That footage was filed into my case, yet it was never presented in trial. Brady versus Maryland, suppressed of. I'm not even going to try to say that word. Under Supreme Court proceedings, if prosecutors or law enforcement fail to present evidence that could impact a verdict, it violates due process and may justify case dismissal or post-conviction relief. Prosecutorial, yeah, that word. Misconduct. ABA Rules of Procedural Misconduct 3.8. Prosecutors must disclose evidence. I'm sure you guys know that word. I have problems with it. If they knowingly withheld it, which I know they did, they could face misconduct investigations. How I'm fighting back and how you can too. What's next? I'm filing a civil rule motion under KRS. I'm sorry, that ain't KRS. It's Kentucky rule. 60.02, citing procedural errors, failure to present key evidence, and police misconduct. Now here's the steps that I could take, and I think I might again. Holding government accountable. Ain't that funny? See, when that officer, I'm not even going to read that, but when that officer come out from talking to my stepdad, nobody there asked me for my statement. Nobody. Not one person. He come straight out of the house and put cuffs on me. Never even tried to talk to me. Like it's not legal. They basically they screwed me over. Like it's not legal. None of it's legal. It's a mess up in due process. It's a lack of, well, the judge said they had probable cause. Oh, well, there was probable cause. Well, no, there's not. I just proved there's no problem. If there's probable cause, I would have the charge of assault. I don't. They dropped the charge because they ruled it self-defense. Therefore, it's a legal action eliminating probable cause. And if the officer would have took my statement before he arrested me, he would have known that, and by his oath to uphold the law, he would have seen KRS 503. Hey, you know what? He said he felt he was in imminent danger. That's illegal. That's legal. It's a legal action. Therefore, there's no probable cause. But they made it probable cause, which led to the illegal search due to the lack of evidence of him not taking my statement, but making my statement from the admissions from the body cams. Admissions is not a statement. It's not a statement. It's not a full statement. If I gave him the full statement, I would have told him I felt like I was in imminent danger, so I defended against him. That would have ruled out probable cause. And the drug paraphernalia would have never been found. See where I'm getting at? But see, Kentucky, stupid. Kentucky law enforcement don't have to take statements. But when it comes to stuff like this, it's a lack of evidence. It's a mess up in due process. Because if they don't take statements, then how they know who's innocent and who's not? Because one person could be lying. They took the statement of my stepfather, the one who actually performed the assault. I asked them to press charges against him. I wanted to press charges against him. They refused to do it. They just come straight out and arrested me. Why? Because they wanted their man.